Bam! Welcome, everybody. Welcome to this episode of The Branca Show, back in the home office. I am, of course, attorney Andrew Branca. So pleased you could join me here today to talk about the death of the vampire rule, the stake driven through the heart of the vampire rule enacted by Hawaii, tried by New York. It has been slain by Justice Samual Alito. He delivered a dagger-sharp stake through the heart of the so-called vampire rule, enacted by Hawaii and other progressive fascist gun control states in their desperate efforts to continue to infringe Americans' Second Amendment rights. Alito was joined by a sharp-eyed concurrence by Justice Amy Coney Barrett. Always nice to see her doing the right thing. In fact, her concurrence was joined by the great and powerful Justice Clarence Thomas, as well as by Gorsuch. Barrett noted that the Democrats continue to rely, in defense of their unconstitutional gun control laws, on racist laws intended to deny civil rights, Second Amendment rights, gun rights to freed black slaves to defend their modern Second Amendment arguments. It's both astonishing, offensive, and totally on brand for the Democrats to be making use of anti-black, the party of Jim Crow, the party of the KKK, the party of slavery, continues to use their anti-black laws to defend their infringements of the U.S. Constitution. Now, if you're not familiar, under the vampire rule, so-called, a person who was otherwise lawfully carrying a concealed firearm for lawful purposes was by default prohibited from entering shops open to the public, pharmacies, gas stations, supermarkets, unless they first secured affirmative permission from the shop owner, effectively a guns welcome here sign on the front of the building. This reversed the until then existing default that lawful carry of firearms was permitted by default unless affirmatively prohibited. The no gun signs we not uncommonly, unfortunately, see on the front of stores and movie theaters and shopping malls. The result of the vampire rule, the flipping of this default from it being default permissible to carry a gun unless told otherwise, to it being default impermissible and a criminal offense to carry guns in places open to the public unless affirmatively given permission, resulted in a profound infringement of the Second Amendment and the ability of law-abiding Americans to lawfully carry arms for lawful purposes as they go about their lawful day. No other civil right would be treated this way. No legislature would pass a law saying you can visibly wear a cross, a Christian cross, but you can't wear it into places that are generally open to the public unless you first get permission, affirmative permission from the store owner that it's okay. That obviously would be an unconstitutional infringement of the First Amendment. Property owners have property rights. It does not give them a right to infringe the civil rights of other Americans. Now, of course, in this decision, the three scrones, we're all familiar. This would be, of course, Justice Elena. No, I never married, never had kids. Why do you ask? Kagan. Justice Sonia, the wise Latina diabetes Sotomayor. And Justice Ketanji Jackson. All dissented from this opinion, naturally. It's interesting, though, that Jackson wrote her own dissent, of course, that's almost as long as the majority opinion. She was joined by Sotomayor, who doesn't like to work all that much, apparently. Kagan would not sign on to their lengthy dissent. She wrote a one-page dissent herself, but of course they're all 100% for infringing Americans' rights to keep and bear arms. Let me get ready to jump into all of this. Let's see, make sure I'm not missing anything. We got a super chat already. Aaron Troyer, gifted one Andrew Branca Show membership. Thank you so much, Aaron. And Eddie Rodriguez, $5. They continue to use anti-Catholic laws as well. I didn't see that, but we'll look for that as we read through it. Yes, anything that's discriminatory, they think justifies ongoing discrimination. The left never changes. The leopard never changes his spots. Never changes its spots. It's remarkable. All right, so I'm going to jump right into the opinion here. I read the summary yesterday, if you were with us for our impromptu show from Knoxville, Tennessee, where my wife and I were checking up on the construction of our new home. But I didn't have time to do an in-depth read because we were on our way to the airport, so that's what we're going to cover right now. Let me pull this up. And get it appropriately sized. Get to the actual start of the opinion proper. There we go. Another great victory, of course, for the Second Amendment. Let's see how we're doing here. That's a little fatter than I would like. I guess we can make that work. Let's try it out. This case is Wolford v. Hawaii. By the way, my buddy Costas Moros, who's worked for I think he's currently working for the Second Amendment Foundation, does a lot of great work on Second Amendment stuff. You should definitely follow him on X. He has a long thread kind of breaking down this decision step by step on X. And I think he wrote that under SAF. SAFDN, for some reason, is, I'll pull it up later. But if you're really interested in this stuff, you may want to check it out there. June 25th, 2026, just yesterday, Justice Samuel Alito delivered the opinion of the Supreme Court. He writes, for years, the state of Hawaii made it almost impossible to obtain a license to carry a firearm. 4 years ago, however, this Supreme Court held in Bruen that the Second and 14th Amendments protect the right to carry handguns outside the home for self-defense. Hawaii responded by replacing its old law on carry permits with new laws that achieved a similar result, making it almost impossible to lawfully carry a firearm. On a large portion of the land within the state's boundaries, possession of a firearm is now flatly prohibited, and the law now before us severely burdens the ability to carry a firearm in much of the rest of the state by prohibiting firearms on private property without the express and affirmative consent of the property owner. It makes it a crime. This law departs sharply from the standard common law rule on access to private property held open to the public. Under that rule, everyone, including those lawfully carrying firearms, may enter unless expressly prohibited from doing so. By contrast, under the new Hawaii law, no one carrying a firearm may enter without the property owner's express authorization. The effect of this new rule is to impose severe restrictions on the daily activities of residents who have satisfied Hawaii's rigorous requirements for the issuance of a carry permit. When those permit holders leave home in the morning, not only must they take care to avoid all the territory where the possession of a gun is prohibited outright, but they may also be barred from entering many places that people routinely visit in the course of their daily routines, such as gas stations, convenience stores, restaurants, coffee shops, drugstores, grocery stores, big box stores, home improvement stores, barber shops or hair salons, dry cleaners, and laundromats. This regime hobbles what the Second Amendment protects: the right of Americans to carry arms for self-defense as they go about their daily lives. We, the Supreme Court, hold that the law, the vampire rule, is unconstitutional. When Hawaii adopted the law now before us, it did so against the backdrop in open rebellion against this Supreme Court's Second Amendment decisions. And many of the arguments that Hawaii now advances were addressed in those decisions. We therefore begin with an overview of that body of law. So this is an overview of the Supreme Court's Second Amendment law, which I always think is worth doing a good thing. The Second Amendment provides, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For more than 2 centuries after the ratification of the Second Amendment, this Supreme Court had few occasions to examine its meaning. Such an occasion arose in the District of Columbia v. Heller, 2008, the first of the modern, seminal Second Amendment cases. The case was brought by Dick Heller. By the way, I've met Dick Heller. I met him, maybe 10 or 15 years ago at a NRA annual meeting. The case was brought by Dick Heller, a resident of the District of Columbia, whose story highlighted the reason why the right to keep and bear arms for self-defense was included in the Bill of Rights and therefore taken outside the purview of the states to regulate. In light of the exceptionally high rate of violent crime in Washington, D.C., Heller wanted to keep a firearm in his home to defend himself in case of a burglary or home invasion. He had all the hallmarks of a citizen who would handle a firearm safely and responsibly. He was a special D.C. police officer who provided security at the Thurgood Marshall Judiciary Building and was authorized under D.C. law to carry a handgun while on duty. But the district, which made it virtually impossible for a resident to keep a handgun at home for self-defense, denied his application for a permit. Unwilling to accept this plight, Heller sued in federal court to vindicate his Second Amendment right. When his case reached this Supreme Court, we provided our first thorough exploration of the Second Amendment's meaning. This was written by Scalia, Antonin Scalia, Heller was. The since departed. Rest in peace, Antonin. We rejected the argument that the Second Amendment right extends only to members of a state militia, which was a common claim in federal courts at the time, and held instead that the Second Amendment, like other provisions of the Bill of Rights, protects an individual right enjoyed by the people. That was the key holding of Heller, that the Second Amendment was an individual right. Our opinion went on to explain the meaning of the Second Amendment's other key terms. The phrase to keep and bear arms, we held, signifies what its terms mean in ordinary usage. That is, to have, keep, and carry, bear arms. And arms, we explained, refers to implements used for offense or defense. We added that handguns, which are overwhelmingly chosen by American society for self-defense, fall squarely into this category of arms. We also identified the amendment's central concern, securing the fundamental right of self-defense. I would argue that's wrong, of course. The central concern of the Second Amendment is securing the fundamental right to overthrow tyranny, but that may have been a step too far in terms of political correctness for the Supreme Court in 2008. In late 18th century America, the need for firearms for self-defense was acute. There were no police forces, and most Americans lived in rural areas, often in homes located miles from the closest neighbor. If these homes were attacked, the residents were on their own, and their survival might depend on the availability of a firearm to ward off assailants. In light of this reality, it's not surprising that the right to keep and bear arms was included among the other treasured liberties protected by the Bill of Rights. Footnote 4. As Heller noted, most Americans in the late 18th century also undoubtedly thought that the codified Second Amendment was important for hunting, which, particularly for those moving west, was an important source of sustenance. Back to Alito. But while the founding generation cherished the Second Amendment right, they did not think it was absolute. Heller explained, and later cases have reiterated, that the Second Amendment codified a pre-existing right. And this right, as understood at the time, was not an unlimited right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. Similarly, Heller warned that nothing in our opinion should be taken to cast doubts on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. Because the Second Amendment protects a right that already existed when the amendment was adopted, Heller instructed courts to ascertain the scope of the right by looking to history. And to emphasize the point, Heller emphatically rejected the ahistorical and judge-empowering interest-balancing inquiry suggested in the dissent. This is back to the old school rational basis, intermediate scrutiny, strict scrutiny standards. These are standards of review. How hard will the Supreme Court look at a law in determining whether or not it's constitutional? And it's all kind of a lie, because whatever standard you pick determines the outcome. If the government enacts a law and someone challenges its constitutionality and you provide only rational basis review, well, then any pretextual reason for the law is sufficient for it to pass constitutional muster. If a law addresses a core constitutional right, it's supposed to have strict scrutiny applied. And if strict scrutiny applies, almost no law survives constitutional examination. So by choosing the standard of review, you effectively choose the outcome. Well, of course, for many decades in the modern era, the federal courts were applying only rational basis to gun control laws, so they were all deemed to be constitutional. It's not until you apply strict scrutiny that you get to a viable, unconstitutional challenge to a gun control law. One of the things the Supreme Court's done, and he'll talk about this in Bruen in particular, is they've stripped away. They actually did this in Heller, as he talks about here. Heller said, no, this balancing test, what's the interest of the government against the interest of the people claiming infringement, and what standard of review do we apply, does not apply to the Second Amendment. You need to use a different mechanism of analysis, a history-based analysis. Heller acknowledged that the history-based analysis it prescribed would not always be easy, but it found that mode of analysis necessary to prevent judges from balancing away the right that the Second Amendment was adopted to protect, which is precisely what the dissent did in this opinion. That would be the three scrones. Heller concerned an ordinance adopted by the District of Columbia, and therefore the decision did not govern the states. It was only on the federal level. But since virtually all the provisions of the Bill of Rights had been held to apply equally to the federal government and the states, it was inevitable that the Supreme Court would have to decide whether the Second Amendment right merited similar treatment. 2 years after Heller, that question came before us in McDonald, which was authored by Justice Clarence Thomas. The case was brought by residents of Chicago. By the way, I've met them too. It's funny. It's a small world. I met them when I taught one of my law of self-defense classes up in Chicago. A city like Washington, D.C., with a high rate of violent crime. The lead plaintiff, Otis McDonald, was a man in his late 70s who lived in a dangerous neighborhood and had been subjected to violent threats from drug dealers. A city ordinance effectively barred McDonald and the other plaintiffs from possessing guns in their homes for self-defense, and they contended that the fundamental right recognized in Heller should apply throughout the country. The city of Chicago opposed nationwide application of Heller, arguing that law enforcement needs and public attitudes about guns varied from state to state and city to city, and that states and cities should have leeway to regulate gun possession as their lawmakers saw fit. In other words, that the Second Amendment means different things in different places of the United States. The Supreme Court, however, disagreed. The plurality opinion, joined by 4 other justices, concluded that the Second Amendment right, like nearly all the rights protected by the First, Fourth, Fifth, Sixth, and Eighth Amendments, should apply equally to the federal government and the states. Following a body of precedent dating back more than a century, the plurality, the majority, concluded that the provision of the 14th Amendment that did this work was the Due Process Clause. Justice Clarence Thomas, who provided the decisive 5th vote and wrote the decision, reached a similar result based on the 14th Amendment's Privileges or Immunities Clause. So 2 different arguments to get to the same place. Thomas emphasized Privileges or Immunities Clause, and the others emphasized the Due Process Clause path, but they all ended up at the same place. The Second Amendment constrains the states' gun control laws as well as the federal government. Alito writes, but either way, McDonald settled the question whether the Second Amendment embodies a uniform national standard or one that varies from one locale to another. And of course, uniform national standard won the day by 5-4. After McDonald, 12 years elapsed before the Supreme Court's next major Second Amendment decision, Bruen. In the interim, lower courts rejected nearly all Second Amendment claims of infringement based on reasoning that resembled that in Justice Breyer's Heller dissent. In other words, the federal courts, in open rebellion against the majority decision of the Supreme Court in Heller, just pretended that the losing argument in Heller, the dissent in Heller, written by Justice Brewer, was the controlling law. It's just so dishonest of these unelected, black-robed, tyrannical, inferior federal district trial court judges. In Bruen, we considered one such decision, which upheld a New York law that severely restricted the right to carry a handgun outside the home for self-defense. In doing so, we fleshed out the process of historical analysis required in a Second Amendment infringement case. That analysis, we held, involves two steps. First, a court must determine whether the law before it clashes with the plain text of the amendment's language. This inquiry entails three subsidiary questions. First, does the law apply to the people, which is to say, to all members of the political community, we, the people? Second, does the law that someone claims is infringing, does it concern any form of arms, that is, any weapon customarily used for offensive or defensive purposes? And third, does the law place any restrictions on either the keeping or the bearing of arms? If a challenged law, a gun control law, falls within the plain meaning text of the Second Amendment, it meets the answer to those three questions is yes. It is presumptively unconstitutional, which means that it may violate the pre-existing right that the Second Amendment codified. But because that right was not in every way coterminous with the amendment's literal language, in other words, the founders would have recognized some restrictions on the right to keep and bear arms, further analysis may be needed. Specifically, the relevant government, federal, state, or local, may be able to show that its challenged law did not infringe the historical understanding of the codified right. A variety of sources, including scholarship, may aid in this inquiry. The inquiry being, would the founders have allowed this particular infringement, what would otherwise be an infringement? But often, the best evidence may be what Bruen called historical analogs. These are old legal rules from which a court may draw a strong inference that the modern law at issue is consistent with the codified right. A party defending against a Second Amendment infringement claim may rely on a single analog of old laws or a group of analogs. Bruen identified three important inquiries that courts should undertake in evaluating the proffered analogs. The first, another three-part test, is the number of jurisdictions in which the analogs were adopted. They were cautious about this. We will not stake our interpretation upon a law in effect in a single state or a single city. The second is the extent to which the laws were well accepted. This acceptance may be express, as when judicial decisions explicitly acknowledge the rule's legality, or the acceptance may be tacit, as when a restriction on the keeping or carrying of arms was open, widespread, and unchallenged. The third criteria on the merits of the historical analog is whether any analog or collection of analogs is relevantly similar to the modern law. How do you determine similarity? Determining whether this condition is met requires consideration of how the analog restricted the keeping or bearing of arms, that is, whether it imposed a restriction similar to that imposed by the challenged law, and a court must also consider why the analog restricted the keeping or bearing of arms, that is, whether its rationale was similar to that of the new law. An example of this being done poorly is, of course, many liberal states have magazine capacity limits on guns. You can only have 15-round magazines or 10-round magazines. artificial limitations on magazine capacity. And to justify this on challenge, they point to what they call as a historical analog. It was a rule about how much gunpowder could be kept in a home at the time of the founding. And that was limited. I think it was 8 pounds. And of course, loose gunpowder is how you fired the firearms of the era. And they say, well, the founders limited how much gunpowder you could have. That's analogous to limiting the number of rounds you can have in a magazine. Well, first of all, it's silly on its face, right? Because there was no limit on how much gunpowder you could carry on your person if you wanted to. You could carry 20 pounds of gunpowder on your person. So why can't you carry 20 pounds worth of ammo in magazines on your person? But in any case, it's the why part that matters here. Why were you limited to 8 pounds of gunpowder at the founding in your home at one time? Because it was deemed a fire hazard. That's why. Not to limit how much you could shoot, but for fire protective purposes. So it was even if you were to accept that it was a similar how, it was a very dissimilar why, and therefore would fail as a historical analog for magazine capacity limits. Alito continues, in order to be sufficiently similar to the modern law being challenged, a putative analog need not be a dead ringer or historical twin, particularly when the modern law addresses a situation that could not have arisen when the Second or 14th Amendment was adopted. It's too much to demand such a close match. But the how and why of the historical analog and modern regulation must be close enough to enable a court to say, because this historical law was understood to be compatible with the limitation on the right codified by the Second Amendment, we can infer that the restriction imposed by the modern law is likewise consistent with the understanding of the Second Amendment at the time of the founding. Making this determination is far more disciplined than the interest balancing or judge empowering standard that Heller emphatically rejected. But it's not mechanical. It undeniably necessitates an exercise of judgment. Applying this framework, Bruen held that the challenged New York law, which broadly prohibited law-abiding citizens from carrying commonly used firearms in public for self-defense, violated the Second and 14th Amendments. We found that the state's proffered analogs, historical analogs, were critically different from the challenged law, and that the overwhelming weight of historical evidence supported the right of the public to peaceably carry handguns for self-defense. In addition to holding that New York's law violated the Second Amendment, we pointed out that 6 other jurisdictions had adopted statutory provisions like New York's. One of those just happened to be Hawaii, which brings us back, of course, to this case. But before I continue, I do have to mention my buddies over at Chapter Medicare Advisors. Chapter Medicare Advisors. Let me pull that up so we have it on the screen. Where are you, Chapter? There you are. So let me ask you a question. Did you know that Medicare agents can legally show you just the Medicare plans that pay them the highest commissions and not even mention others that are lower cost, that are a better fit for your healthcare needs? These brokers have no fiduciary duty to you. None. Good, honest help in the Medicare space can be hard to come by, leaving you and many others overpaying for Medicare. So if you're on Medicare, or you see it approaching, or you have a loved one on Medicare, or who sees it approaching, that's why I want to tell you about my good friends at Chapter. They are independent Medicare advisors. They compare every plan, over 24,000 of them, from every carrier, to get you the best doctors, the best prescriptions, the best healthcare priorities, the one that actually fits you best. And here's how you know they're honest. This is how I know they're honest. I get the comments from my community, the Brankus Show community. You'll see them in the chat. People call. They say, they saved me thousands of dollars, which is the historical norm, is that Chapter members who follow their advice get less costly health care, better aligned with their health care needs, and save thousands of dollars in the process. And if you happen to have the best Medicare plan already at the best price for you, they'll tell you so. Chapter does not do a hard sell. Just give them a call, and they'll advise you on where your Medicare plan may fall short, how to save tons of money, and get even better Medicare. That's at 617-644-0093. They're very friendly people. 617-644-0093. I've had members of the Branca community tell me I called them, and they didn't sell me a damn thing. They didn't tell me to change anything. They said, no, that plan you're on, that's the best one for you at the best price. So again, you'll never get a hard sell from Chapter Medicare advisors, which is why, of course, that I recommend you give them a call. Perhaps the best part, by the way, is none of this costs you a penny. Chapter does not charge you a penny. It's only upside, folks. All you can do. The worst case scenario is they tell you you're all set. The best case scenario is they line you up with a better aligned healthcare plan for you, Medicare plan for you, and they save you thousands of dollars. So don't get suckered by the brokers who are just looking for a high commission. Call Chapter. It's free, takes less than 20 minutes. Give them a call at 617-644-0093. Tell them I sent you. You don't have to do that, but they know me. We're friends. They always get a laugh out of that. Tell them Andrew sent you, the Branca Show sent you, and stop getting ripped off by these horrible Medicare brokers. All right, as long as I paused, let's see. Do I need to catch up on a couple super chats and a Rumble rant? Spuds, $2 says, Scalia unfortunately succumbed to the Clintonitis, yeah. Just died in his sleep. No apparent reason. Sean Henderson sent $5. Thank you very much, Sean. There's Sean, and there's Spuds. Sorry, I forgot to pull that up. And over on Rumble rant, $5 from Zakuza. Thank you, man. Says, mowing the lawn, continue to give me that good Second Amendment news. That's why I'm here, brother, to share the good news. And over on X, despite the assault weapons ban, Washington State doesn't do this and still allows open carry. Glad to see SCOTUS making strides in correcting Democrat overreach. Well, you know, Washington's going to pass all the gun control laws that the Supreme Court lets them get away with. It's only a matter of time. It's only a matter of time. Sorry, but the liberals have taken over your state, as I'm sure you know better than anybody. All right, continuing with this. In Bruen, the law at issue concerned conduct that could have occurred when the Second and 14th Amendments were adopted, carrying a handgun outside the home for self-defense. By contrast, in our most recent Second Amendment case, United States versus Rahimi, the law in question involved conduct that was distinctly modern. The possession of a firearm by a person against whom a domestic violence restraining order had been issued. Accordingly, application of Step 2 of the Bruen framework called for a more difficult exercise of judgment. In the end, however, the majority was satisfied that the two analogs identified by the federal government, though not dead ringers, were sufficiently similar to support the provision's constitutionality because the challenged regulation was consistent with the principles that underpin our regulatory tradition. In other words, no guns for people with a domestic violence restraining order. The founders would have accepted that unlawfully violent people can be denied the right to keep and bear arms. I believe, by the way, Clarence Thomas dissented in Rahimi, if I recall correctly. The dissent applied the same test, but came to the opposite conclusion. Oh yeah, here it is. He did. Exhibiting how Heller's history-based methodology, true to the warning contained in that groundbreaking decision, is not mechanical. Section 2A. With this background in mind, we turn to the Hawaii law challenged in this case. Before Bruen, Hawaii issued firearms carry license only in exceptional cases. Indeed, it would appear that from 2000 to 2018, 18 years, only 4 such licenses were issued. After Bruen, which said you had to issue licenses, Hawaii and 4 of the other 5 states called out by our decision in Bruen adopted a new method of restricting law-abiding citizens from carrying firearms for self-defense by flipping the the default rule on private property open to the public, creating the so-called vampire rule. At common law, opening up private property to the general public implies a license to all persons to enter, meaning that no person is a trespasser by merely entering therein unless the property owner has given due notice that such a person is banned. After Bruen, Hawaii and 4 other states singled out in that decision, flipped this default rule. Rather than allowing all to enter private property open to the public unless specifically prohibited, these new laws provided that no one carrying a firearm may enter without express authorization. Hawaii's new default rule is part of a tight web of laws that severely restricts the carrying of firearms for lawful self-defense. To start, carrying a handgun for self-defense requires a special license, and obtaining that license is a rigorous process. Also, probably unconstitutional, right? There is no historical analog for concealed carry licenses as a preemptive requirement for otherwise law-abiding carry. Applicants must first complete a detailed application that requires the disclosure of medical information. They must then successfully complete an extensive training course in which they demonstrate competency in firearm safety and live fire shooting, as well as an understanding of the law and available mental health resources. It's like they're presumptively insane if they want to carry a gun. And they must demonstrate the essential character or temperament necessary to be entrusted with a firearm. But even for those who fulfill these stringent requirements, Hawaii imposes 2 additional restrictions on carrying firearms. The first bans the possession of a firearm in significant categories of places, any state-owned building or adjacent grounds and parking area, so the parking lot, any public or private hospital, or other place at which medical or health services are customarily provided, any restaurant serving alcohol, any stadium, movie theater, or concert hall. Thank God there aren't mass shootings in movie theaters, right? Any public library property where the homeless go to hang out, any public or private college or university, any public school, charter school or private school, any beach, playground or park, any bank or financial institution, any amusement park, aquarium, carnival, circus, fair, museum, water park, or zoo, and any public gathering, public assembly, or special event conducted on property open to the public. Some of these places are owned by the state, but many of the categories include privately owned property. So even if the owner of such a place wanted to admit individuals who were carrying a gun for self-defense, the owner could not do so. By the way, Hawaii has been claiming throughout that this was not a gun law issue. This was simply a property rights issue. But they don't mind constraining property rights of private citizens. The second restriction of Hawaii, the one at issue in this case, generally prohibits licensed individuals from carrying a firearm, even if unloaded or inoperable, on private property of another. Certain categories of individuals, such as police officers, are exempt, but the ban otherwise applies unless express authorization has been given by the owner, lessee, operator, or manager of the property. Such an authorization must take one of 2 forms: clear and conspicuous signage that confers such consent, or unambiguous written or verbal authorization to carry a firearm on the premises from the owner, lessee, operator, or manager of the property, or an agent of such a person. Petitioners, 3 residents of Maui County in Hawaii who possess concealed carry permits, and an organizational plaintiff with members who have such permits, might have been the Second Amendment Foundation, contend that these restrictions violate their rights under the U.S. Constitution, and they filed suit in federal court seeking both temporary and permanent injunctive relief. In other words, that the law, the vampire rule, cannot be enforced. By the way, there's a footnote here I wanted to get to. Where was it? Oh, here it is. When they first introduced the vampire law. Footnote 9. In the decision below, so this decision was, the decision below was from the Court of Appeals en banc, which allowed the vampire rule to remain in effect. There was a dissent, of course. 6 judges stated that Hawaii's law prohibits presumptively or outright the carrying of handguns on 96.4% of the publicly accessible land in Maui County. Who wrote that? Judge Van Dyke on the Ninth Circuit Court of Appeals, who was amazingly good on Second Amendment issues. This shout out did not have to happen. This footnote is not necessary to this decision. I can't help but feel that Alito is giving this shout out personally to Van Dyke, maybe to buttress Van Dyke's credentials for his own future admission to the U.S. Supreme Court, which would be amazing. Van Dyke is fantastic. The district trial court declined to enjoin the statute with respect to private property that's closed to the public, but it enjoined enforcement of the new default rule, the vampire rule, as it applied to private property that is open to the public. So these three people and the organization sued the vampire rule. Vampire rule's unconstitutional infringement, and the trial court agreed. The vampire rule is an unconstitutional infringement of the Second Amendment as it applies to places normally open to the public, not a homeowner's private property, but stores, gas stations, all that jazz. You're presumptively, by default, allowed to lawfully carry a gun on that property unless it's posted no guns. You don't have to get affirmative permission first to carry there. Well, Hawaii appealed this to the Ninth Circuit Court of Appeals, 3-judge panel, and that panel of the Ninth Circuit reversed the injunction, and the full Ninth Circuit denied a rehearing en banc. So now the vampire rule's back in effect. The parties petitioned for the entire Ninth Circuit, or a large chunk of it, not just the 3 judges, to rehear the case in the hope that they would reverse the reversal and take the vampire rule back off the table. The Ninth Circuit refused, denied the request to hear it en banc, and that's where we find Judge Van Dyke's dissent. Judge Van Dyke, joined by 5 other judges, issued an opinion dissenting from the denial of rehearing en banc. Judge Collins, joined by Judge Bress, likewise filed a dissent. We, the Supreme Court, granted certiorari to decide whether Hawaii may prohibit licensed concealed carry permit holders from carrying handguns on private property open to the public unless the property owner gives express permission. The analysis. Let's see, how are we doing? A couple super chats. Let me catch up on those here. Tread 1775 generously gifted 5 memberships, and he comments $5 here. I need to cut back on my cigar budget since gift membership went up. We did increase the cost of membership on the Branca Show by I think a couple dollars. That does not affect those of you who were already members. Your cost has not gone up. It's frozen. It applies only to people who become members moving forward, and I guess it applies to the gift memberships too. Thanks, Tread. I really appreciate that, man. It's very generous of you, as always. Okay, back to this. As with any Second Amendment challenge, we began by asking whether the restriction imposed by the law falls within the plain text of the Second Amendment. And we find that this requirement, is easily met by the vampire rule. No party disputes that the petitioners are among we the people protected by the Second Amendment, or that they seek to carry arms. Therefore, the plain text of the Second Amendment protects what petitioners want to do, carry handguns for self-defense on property open to the public, and it's presumptively unconstitutional to infringe their right to do that. Petitioners and the United States, the people who want to do away with the vampire rule, argue that the new default rule, the vampire rule, was enacted specifically to undermine our decision in Bruen. But whatever the purpose of the new law, so Alito here is saying, yeah, we know they're shitbags. They're just pretextually raising barriers to public lawful carry because they don't like it. And now we force them with Bruen to issue permits, so they're going to make it complicated in other ways. But we're not going to engage here, Alito says, in mind reading. Whatever the purpose of the new law, the shift from the old common law rule unquestionably imposed a new and significant burden on the exercise of the right, lawful concealed carry in public, that this Supreme Court recognized in Bruen. To be sure, owners of establishments that are open to the public can admit or exclude Persons who are carrying guns for self-defense under either the common law rule, lawful by default, or the Hawaii vampire rule, unlawful by default. As a practical matter, however, the choice between these two default rules is often outcome determinative with respect to Hawaiians' Second Amendment rights. For establishments where the owner either pays no attention or does not care about such issues, the choice of default rule, default permitted or default criminal, will determine where carry permit holders may lawfully carry firearms. More broadly, Hawaii's new default rule, vampire rule, burdens those wishing to exercise their Second Amendment right. Some proprietors who do not themselves object to entry by carry permit holders may be reluctant to post a sign welcoming such individuals, guns allowed, for fear of alienating other customers. So under Hawaii's new default rule, a proprietor in this category may only be willing to consent discreetly to the entry of permit holders who make the effort to ask for permission. This arrangement imposes a new burden on permit holders who will have to somehow obtain permission to carry a firearm on the property before stepping foot on the property. To see what Hawaii's new default rule means, vampire rule means in practice, consider its impact on a resident of Hawaii whose situation is like that of Jamie Caetano, a young Boston woman who wanted to carry a weapon to defend herself from a violent ex-boyfriend, but was criminally prosecuted when she used a non-lethal weapon, it was a taser, to defend him. Massachusetts had made private carry of tasers illegal. Suppose our hypothetical young woman, after clearing all the hurdles needed to get a Hawaiian carry permit, leaves her home on a weekday morning and carries a handgun on her person or in a purse. On the way to work, she intends to fill up her car at a gas station. During her lunch break, she plans to walk to a fast food restaurant and then buy some items at a large drugstore. After work, she wants to pick up clothes at a dry cleaner and then shop for groceries. Unless each of these establishments has posted a sign saying guns welcome or something to that effect, each visit would expose her to criminal liability. Imagine what our hypothetical young woman will have to do when she drives to the supermarket after work. When she arrives, she will violate the literal terms of the Hawaii vampire rule merely by pulling into the parking lot while having her handgun concealed on her person. She can minimize the length of her violation by disarming as soon as she arrives. But in removing the handgun from her person, she must take care not to let anyone see it for even a moment. Otherwise, she could be charged with recklessly causing alarm to another by failing to conceal the firearm even briefly. Once she has removed the handgun from her person, she cannot leave it in her car without locking it in what amounts to a safe. Instead of going through all this, she may choose to remain armed when she enters the supermarket and promptly search for someone who's authorized to provide the consent that the vampire rule demands. This will prolong the violation of the vampire rule, and finding someone who can provide consent may not be easy. For example, it's most unlikely that the supermarket employee who's gathering up shopping carts in the parking lot or the employee who is restocking shelves will possess the authority to grant permission to carry a gun lawfully onto the property. During all the time this search goes on, our hypothetical young woman will be violating the vampire statute, and if that is brought to the attention of the police, say by a store employee or a customer who hears her ask for permission to enter while armed, she may be charged with a criminal offense or lose her concealed carry license. And in the end, she may be unable to shop because she cannot find anyone who has been authorized by management to consent to her being armed. When our hypothetical young woman visits the restaurant at lunch, her situation may be even more difficult. Unless her place of employment has a gun locker where she can store her gun, she may be unable to leave it behind when she leaves the building. And as she disarms before leaving work, she will be vulnerable for that period of time. Even this short period of vulnerability can be deadly. The Miss Caetano, Massachusetts taser case, Miss Caetano was approached by her abusive boyfriend right after leaving work. If our hypothetical young woman remains armed during the lunch break, she will violate the vampire law if she sets foot inside any establishment without a guns welcome sign, even if she immediately seeks someone who can provide authorization to stay. And as was the case with the supermarket, finding such a person may not be easy. Thus, by the end of an ordinary day, our hypothetical young woman could be a criminal at least 6 times over. In short, Hawaii's law severely hampers the ability of a law-abiding citizen to exercise the right Bruen recognized. Hawaii nonetheless argues that petitioner's challenge fails at the first step of Bruen's 2-step framework because the right to bear arms did not encompass the right to armed entry onto private property without the owner's consent. The state then launches into a lengthy discussion of historical materials and precedents that it contends support this argument. We will discuss all these authorities, but they are out of place at Bruen's first step, which only asks, is the conduct within the scope of the Second Amendment? At that stage, as we have explained, the question is simply whether a challenged law falls within the Second Amendment's plain text. It does. So we therefore move on to the second step, the historical analogs. At the second step, the inquiry mandated by Heller and Bruen turns to an exploration of the historical understanding of the scope of the right the Constitution codified. Hawaii's first argument on this score is based on Hawaii's particular customs and laws. The state starts with the undisputed principle that the owner of private property is generally free to exclude anyone from entering without consent. It acknowledges that an owner's consent need not always be express, and that there are circumstances in which consent may be inferred, like when you're generally open to the public, like a shop. But the state contends that whatever the situation in other parts of the country, in Hawaii, opening private property to the public does not implicitly include any armed individuals, lawfully armed, among those who may enter. In support of this argument, Hawaii recounts its long history of antipathy to the private possession of firearms. It tells us that one of the very first written laws of the Kingdom of Hawaii, issued in 1833, obviously long before Hawaii was a state of the United States, by King Kamehameha III, prohibited the possession of all deadly weapons. Later laws adopted before and after Hawaii became part of the United States continued to heavily restrict the possession and carriage of firearms. So here's the problem with this all Hawaii tradition thing. When a group of people, a territory, becomes a state of the U.S., it expressly agrees to be bound by the U.S. Constitution in the same way as every other state, in the same way as the 13 original states. You're not becoming a different flavor of U.S. state. The U.S. Constitution applies to you in the same way. There's not 50 different versions of the U.S. Constitution. And in fact, when Hawaii became a state, by the way, it had tons of limitations on guns, private ownership of guns. And the legislature had to repeal almost all of them as a condition of becoming a state of the United States. Then afterwards, of course, they started to adopt them again. Prior to Bruen, Hawaii permitted public carry only in exceptional cases when an applicant showed reason to fear injury to the applicant's person or property. Then in the wake of Bruen, which said you have to issue permits to otherwise law-abiding people, Hawaii passed the statute at issue in this case, the vampire rule, and Hawaii contends that this law continues a Hawaiian tradition and shows that Hawaiians disfavor the carrying of guns in their midst. Accordingly, Hawaii maintains its new default rule merely expresses the circumstances under which implied consent may be reasonably inferred in Hawaii. In Hawaii. Interesting footnote here, by the way. Alito notes, Hawaii curiously suggests that the concept of private property that's open to the public is too fuzzy for use in ascertaining implied consent, as has always been done. But Hawaiian law uses that familiar concept in a variety of other contexts. For example, definition of criminal trespass. If a shop is open to the public and you walk in, you're not committing trespass. It's assumed that there's an implied consent for you to enter. Now, if they tell you you have to leave and you don't leave, then you're committing trespass. This argument that Hawaii is special and should be able to have its own flavor of the Second Amendment is little different from the central arguments offered by the city of Chicago in McDonald, and Hawaii's version of this argument fares no better. It lost in Chicago, of course. As the plurality explained in McDonald, the Chicago case, the Second Amendment has the same meaning in all parts of the U.S. It cannot give way to the spirit of Aloha in Hawaii, which was actually a quote. The Hawaiian Supreme Court upheld the constitutionality of its vampire rule by reference to the spirit of Aloha as a legal argument. It cannot give way, the U.S. Constitution cannot give way to the spirit of Aloha in Hawaii any more than it can yield to the spirit of the Big Apple. The Bruen case involved New York, or the spirit of the Windy City, the McDonald case out of Chicago. The Second Amendment applies in the same way to our 50th state, Hawaii, where 8% of adults possess guns, and the same way in our 49th state, which would have been Alaska, where the figure is roughly 59% of adults possess guns. Merely local attitudes can neither shrink nor inflate the meaning of fundamental Bill of Rights guarantees that apply to the states through the 14th Amendment. When we assess whether a challenged law is consistent with the right of the Second Amendment codified, with the right the Second Amendment codified, we seek the general understanding of that codified right at the relevant point in time when it was ratified. An outlier legal rule adopted in a few locales is not enough. And as we have explained, overwhelming evidence shows an enduring American tradition permitting public carry. Hawaii's prohibitions on public carry represent a distinct outlier. With this preliminary question out of the way, we turn to Hawaii's main argument that analogous colonial and early state laws support the constitutionality of the state's new law, the vampire rule. These old laws, however, are vastly different from Hawaii's new vampire rule. They consist almost entirely of laws that prohibited unauthorized hunting of deer or small game on someone else's private property. Hawaii's earliest analog is a 1721 Pennsylvania law entitled An Act to Prevent the Killing of Deer Out of Season and Against Carrying of Guns and Hunting by Persons Not Qualified. This statute made it unlawful to carry any gun or hunt on the improved or enclosed lands of any plantation other than his own without securing license or permission from the owner of such lands or plantations. The law's stated purpose was to prevent diverse abuses, damages, and inconveniences that had arisen by persons carrying guns and presuming to hunt on other people's lands. As the Third Circuit observed, that law appears to be primarily focused on preventing Pennsylvanians from hunting on their neighbor's land, not on restricting the right to publicly carry a gun. A 1722 New Jersey statute contains nearly identical language. It's an act to prevent the killing of deer out of season. And a 1728 Maryland statute and a 1763 New York law fall into the same category. The Maryland law, entitled An Act to Encourage the Destroying of Wolves, Crows, and Squirrels, made it unlawful to come to hunt with guns or dogs within any enclosed grounds, islands, peninsulas, or necks fenced across from water to water without leave or license from the proprietors thereof. And the New York law, titled An Act to Prevent Hunting with Firearms in the City of New York, made it unlawful to carry, shoot, or discharge any musket, fowling piece, or other firearm whatsoever into, upon, or through any orchard, garden, cornfield, or other enclosed land whatsoever. All these laws targeted unauthorized hunting and focused on land where game could be found. A 1771 New Jersey law followed this tradition. titled An Act for the Preservation of Deer and Other Game to Prevent Trespassing with Guns. This law provided that a person could not carry any gun on any lands not his own and for which the owner pays taxes or is in his lawful possession, unless he hath license or permission in writing from the owner or owners or legal possessor. In some, Hawaii's analogs principally targeted unauthorized hunting. Their coverage differed sharply from that of the vampire rule now before us. They applied to land where game could be found, not retail establishments that residents of cities and suburbs frequent as part of their daily routines. Those hunting laws had little of any impact on the Second Amendment's central objective, protecting the fundamental right to self-defense. And their obvious aim was to prevent the distinctive harms and risks associated with unauthorized hunting. That conduct often entailed the theft of private property. The poacher took game that the property owner might have otherwise harvested. It involved the firing of guns, firing, not just carrying, which created a risk of inadvertently inflicting death or serious injury on the owner of the property. Others who were authorized to use the property and livestock. At a minimum, the sound of the gunshots could surprise, alarm, or disturb the tranquility of others on the property. The conduct restricted by the Hawaii vampire rule has none of those effects. Others in the premises will not even notice a person peacefully carrying a concealed weapon in the manner demanded by Hawaiian concealed carry law. To test whether these analogs are relevantly similar to the challenged Hawaii vampire rule, we asked the question set out earlier. Because it was accepted that prohibiting unauthorized hunting on private land was consistent with a limitation on the Second Amendment right, can we infer that it's also consistent with that right to ban a person who's lawfully carrying a concealed handgun for self-defense from entering a gas station, coffee shop, grocery store, or other private property open to the public without express and ambiguous consent? The question answers itself. The gap between Hawaii's anti-poaching analogs and its vampire rule is just too wide. The state's two remaining analogs are even weaker. The first is an 1893 Oregon law. So now we're away from the founding and we're post-Civil War. That's relevant because the 13th, 14th, and 15th Amendments were passed post-Civil War, and they are what imposes the Bill of Rights on the states. So the understanding of the Second Amendment at that time is also legally relevant. The first is an 1893 Oregon law that prohibited anyone other than an officer on lawful business from being armed or trespassing on any enclosed premises or lands without the consent of the owner. On its face, it's not clear that this statute is relevant to the issue before us. For one thing, even if commercial establishments that are open to the public were considered enclosed at the time of the adoption of the Bill of Rights, no Oregon authority shows that the Oregon statute used the term to refer to such establishments. To the contrary, Oregon courts have interpreted the phrase enclosed land as outdoor land, surrounded by a visible or distinctive line that demonstrates its separation from contiguous properties. I guess what we would know today as posted land, such that a hunter would know to seek permission before hunting. It's thus unlikely that the 1893 Oregon law used the term enclosed to refer to businesses open to the public rather than to private lands on which poaching was a problem. Moreover, the statute does not demand that consent be express, but even if this provision is read as Hawaii would have us read it, a lone statute adopted nearly a century after the adoption of the Second Amendment and well after the adoption of the 14th Amendment sheds little, if any, light on the meaning of the Second Amendment right. Finally, we come to Hawaii's most remarkable analog. An 1865 Louisiana statute that made it unlawful for any person or persons to carry firearms on the premises of plantations of any citizen without the consent of the owner or proprietor, other than in lawful discharge of a civil or military order. Regardless of this provision's pedigree, it has no probative value for the present purposes. As we have said, in considering the probative value of a historical analog, we must consider whether it was widespread, well-known, and widely accepted. Because this statute was neither widespread nor widely accepted, it carries no weight here. We could stop there, but there's another reason for rejecting Hawaii's reliance on this particular statute. It was adopted by the Louisiana legislature between the end of the Civil War and the beginning of Reconstruction. When the war ended, the legislatures in the defeated Confederate states quickly enacted so-called black codes that aimed to perpetuate the subjugation of blacks, racist Democrats being racist. The statute Hawaii cites was part of Louisiana's Black Code, racist Black Code, and it provided a tool for disarming blacks and thus leaving them defenseless against attacks. Again, another shout out by name to Judge Van Dyke on the Ninth Circuit Court of Appeals, who talked about this in his dissent to the denial to rehear the vampire case en banc. Alito writes, as we laid out in McDonald, the right to keep and bear arms was crucially important for vulnerable blacks during this period. And this was well understood by the Republicans in Congress, who were responsible for drafting, approving, and securing the ratification of the 14th Amendment. The Republican Party platforms of 1856 and 1860 called for protection of the right to keep and bear arms for self-defense. Unless we put history entirely out of our minds, Hawaii's claim that this tainted artifact, Black Code, illuminates the original understanding of the right to keep and bear arms cannot be taken seriously. The vampire rule at issue here violates the constitutional right to keep and bear arms. The judgment of the Court of Appeals for the Ninth Circuit is reversed, and the case is remanded to the trial court for further proceedings consistent with this opinion, which means the law is unconstitutional and will be permanently enjoined. And then we have this concurrence from Justice Amy Coney Barrett, with whom Justice Clarence Thomas and Justice Gorsuch concur. Barrett writes, I join the Supreme Court's opinion in full. So these three are adding their voice to Alito. I write to add a few points about why Hawaii's law triggers and fails Second Amendment scrutiny. Hawaii, in the principal dissent, that would be, of course, Justice Ketanji Brown Jackson, joined by Sotomayor. Hawaii, in the principal dissent, insists that this case is about property law, not the Second Amendment. The argument goes like this: no one has the right to enter private property, let alone to bring a firearm onto it, without the owner's consent. Whether consent can be implied or must be expressed depends on local custom and property rules, which states have always had authority to modify. By requiring express consent, Hawaii has simply modified a default rule of property law. And because the pre-existing Second Amendment right did not require any particular default rule, Hawaii's law does not even implicate the Second Amendment. That's, again, Jackson. According to Jackson, no further analysis is necessary. Barrett writes, this argument misunderstands the role of historical evidence in a Second Amendment challenge. Bruen establishes a two-part test for assessing whether a modern law is consistent with the Second Amendment. Each step requires a court to look at different evidence: plain text of the Second Amendment at first, tradition at the second, but together the two steps illuminate the original scope of the Second Amendment, right to keep and bear arms. While history is relevant to both steps, it plays a different role at each one. We look to history that elucidates how contemporaries at the time of the founding understood the text. For example, the meaning of the phrase, to bear arms. We look at that at Bruen's first step. We save historical gun regulations, however, for Bruen's second step. In this case, Bruen's first step is easily satisfied. Petitioners are members of the people who wish to bear arms onto private property open to the public. The vampire law makes that a crime. For a licensed person carrying a firearm to intentionally, knowingly, or recklessly enter or remain on private property of another while carrying a loaded or unloaded firearm, whether the firearm is operable or not, and whether the firearm is concealed or unconcealed, unless the person has been given express authorization to carry a firearm on the property. This is obviously a regulation of arms-bearing conduct, so it falls within the Second Amendment's plain text. Whether the law nevertheless comports with our historical tradition of firearms regulation, including the traditional property laws that Hawaii invokes today, is a question for Bruen's second step, not the first step. It is irrelevant for purposes of the Second Amendment's plain text, the first step, that a property owner has the right to exclude anyone who wishes to enter her property with firearms. No one doubts that all property owners in Hawaii could bar the carry of arms on their respective premises if they wanted to. But the Second Amendment does not apply to private parties. It does apply to the states. And when a state enacts a property law that regulates arms-bearing conduct, that law implicates the Second Amendment. Consider how Hawaii and the principal dissent's argument would play out in another context if it was a First Amendment, not a Second Amendment issue. What if a state made it a crime to wear a religious headgarb, say a hijab, onto private property open to the public without obtaining express authorization to wear a hijab? Could that statute evade constitutional scrutiny? On Hawaii and Justice Ketanji Brown Jackson's logic, the answer is apparently yes. No one has the right to enter another's property without permission, and the state has merely adjusted the default to require permission to be clear and express. But that is plainly wrong. Because the law regulates religious and expressive conduct, its enactment is state action that triggers First Amendment scrutiny. The same goes for a default rule like Hawaii's that targets the right to bear arms. Property laws, no less than other laws, are subject to constitutional limits. So when a property law restricts the bearing of arms, the state must prove that the law abides by the limits of the Second Amendment. The Second Amendment secures the pre-existing right of the people to have and carry weapons for their defense, but that right was not unlimited at the founding, and it is not unlimited today. Now, as then, states may regulate the keeping and bearing of arms so long as they do not infringe the right as originally understood. To determine when a modern regulation crosses the line, we assess whether it comports with the nation's historical tradition of firearm regulation by asking why and how states historically regulated the Second Amendment right. We can identify the range of permissible regulatory goals and how far states may go to achieve them. Both the end pursued, the how, and the means deployed, well, the end pursued would be the why, and the means deployed, the how, must be consistent with the principles that underpin our regulatory tradition. Under Hawaii's vampire rule, no licensed individuals, with narrow exceptions like police, can carry a gun onto someone else's property, even if it's held open to the public, without express and unambiguous authorization. Hawaii explains that this law reflects the spirit of Aloha, Hawaiians' aversion to the public carry of weapons, and attitude of restrictive gun laws. Hawaii represents that Hawaiians do not think that people should be able to carry guns onto private property, even if it's held open to the public, unless they obtain express consent. In fact, the overwhelming majority of Hawaiians agree that loaded concealed firearms should not be allowed into businesses at all. These attitudes appear to reflect Hawaii's Aloha spirit, which, as explained by the Supreme Court of Hawaii, clashes with a federally mandated lifestyle that lets citizens walk around with deadly weapons during day-to-day activities. To satisfy Bruen, Hawaii must identify historical laws that pursued an analogous goal in an analogous way. Hawaii draws two analogies, one to 18th century anti-poaching laws, and the other to 19th century laws that were mostly designed to suppress newly freed black slaves. The analogies fail. Hawaii first points to several 18th century laws that, broadly speaking, prohibited the carry of firearms onto certain property without the owner's consent. I'm going to skip over this because Alito covered it. It was the poaching laws she's talking about here, the anti-poaching laws. Save some time here. The problem with Hawaii's default rule, the vampire rule, is not that it targets a regulatory problem besides poaching. It's that the rule does not target any particular abuse of firearms at all. Rather than identifying a specific threat to public peace and safety, Hawaii admits it enacted the rule because many of its citizens oppose the public carry of guns. In other words, Hawaii is responding to the general danger associated with the presence of firearms generally, not to any specific heightened risk of their misuse. And rather than confining the rule to specific places where firearms are likely to be misused, Hawaii applies it to all private property, even property held open to the public. From the hardware store to the gas station to the fast food restaurant, individuals cannot carry weapons for self-defense unless they obtain express consent. The 18th century anti-poaching regulations do not support such a rule. Mere disapproval of protected conduct is not a valid reason for the state to severely restrict it. This footnote is worth reading. Hawaii already prohibits the carry of firearms in places that it deems sensitive, including schools, banks, and establishments serving alcohol. So Hawaii cannot credibly say that the separate default rule, which applies to all private property, targets anything more specific than the general risk associated with carrying firearms generally. So those were the anti-poaching analogs. Hawaii also notes that several states enacted similar default rules in the mid to late 19th century. These laws get Hawaii nowhere. Once again, look to their why. Hawaii offers no evidence that these laws were designed to vindicate, these would have been the 1890 post-Civil War laws, to vindicate the community's aversion to people carrying guns in public. Nor is it plausible that they rested on such a basis. At the time, guns were commonly owned for self-defense and hunting, and that trend only increased when many Civil War veterans brought their weapons home. And while state courts often upheld gun regulations during this period, they did so because the states were pursuing specific regulatory ends, not because they were hostile to gun rights. In fact, Hawaii does not dispute that most of the 19th century laws were understood not to address the carry of guns in general, but to curtail the freedom of blacks in particular. After the Civil War, the labor market in the South was a source of considerable irritation to the white land-owning class. Newly emancipated slaves were prone to test their freedom by coming and going as they pleased, and their liberty to forage, hunt, and fish for food reduced their incentive to work on plantations. Now forced to compete for black labor, white landowners resented how blacks could provide for themselves and concluded that they would not work on plantations unless compelled to do so. So Southern states enacted a series of harsh laws known as the Black Codes to stabilize the black workforce and limit its economic options apart from plantation labor. Louisiana was one of those states. In 1865, 3 of its local governments enacted sweeping measures that one observer described as restoring slavery in substance. Among other things, those ordinances prohibited blacks from renting or keeping a house within town limits, barred them from entering the town without permission of their employers, and forbade them from carrying weapons without authorization. Fearing backlash from Congress, the state government opted for a subtler approach. In the fall of that same year, the Democrat-controlled legislature convened a special session and tasked a joint committee with proposing legislation to make freedmen's, black, labor available to the agricultural interest of the state. The resulting package of laws was facially race neutral, but no one was under any illusions about its true aims. As the eventual mayor of New Orleans remarked, the whole thought and time of the special session was given to plans for getting things back as near to slavery as possible. Ostensibly neutral measures like these, we have recognized, were really consciously conceived methods of resurrecting the incidents of slavery. One provision of Louisiana's Black Code was the vampire rule that Hawaii invokes today. At the time, Louisiana apparently did not restrict by statute where individuals can hunt for game. But under the state's 1865 law, no one was permitted to carry firearms on the premises or plantations of another without his permission. Like the other components of Louisiana's racist Black Code, this law was designed to control black labor. It restricted the ability of blacks to feed themselves on open land, thus pushing them into the agricultural labor market. In addition, by presumptively banning the carry of firearms on private property, the law put blacks at a further disadvantage in protecting themselves against private violence. Barrett writes, "It is beyond me why Hawaii would claim that these vile, racist laws can justify its present-day restriction. We can put aside the question of whether they are legitimate evidence of the Second Amendment scope, because regardless, they do not help Hawaii. Hawaii seems to think that Bruen is a matching game. Southern states enacted broad default rules, Hawaii reasons, so we can do the same today. But even if Hawaii is right that the how is analogous, it must also identify an analogous why. The Black Codes were enacted to subordinate newly freed slaves. Hawaii obviously does not contend that its vampire rule promotes an analogous interest. So its law, the vampire rule, and the default rules in the Black Codes are not relevantly similar. Most would take that, Barrett writes, as a compliment. Applying old principles to new circumstances is not always easy. This case, however, is not hard. While most Hawaiians might prefer that no one carry firearms in public places, a majority's opposition to a constitutional right is not a permissible base for restricting that right. After all, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy and place them beyond the reach of majorities and officials. The Bill of Rights is mostly intended to protect the rights of the minority. And that is Barrett. We get to Kagan. She's only got about a page, but I'm not going to bother reading it. And then we get to Justice Ketanji, good old Ketanji, Brown, Jackson. She wrote a dissent. Sotomayor joins. I'm not going to read this whole thing. It's almost as long as what we've already read, but I'll just read the first two paragraphs to give you a sense of the flavor of it. Because it's usual ceiling bird contempt. Insulting the majority, the other justices. Jackson writes, today the Supreme Court declares unconstitutional Hawaii's efforts to protect the rights of its residents. I mean, right there, it's laughable. The Supreme Court just protected the Second Amendment rights of its residents. Both those who wish to carry guns and those who prefer that guns are not carried on their private property without their express permission. This can still be asserted. All the premises need to do is put up a no-gun sign. To hear the majority tell it, Hawaii's law is a blatant attempt to end-run our Second Amendment precedents. Heller, McDonald, Rahimi, Catino, Bruen. But the statute at issue does no such thing, Ketanji says. Instead, it fairly applies a first principle of property law, the right to exclude, and does no harm to the Second Amendment. The majority thinks otherwise. It reaches today's result by purporting to apply the test we established in Bruen. But the majority gets both the Bruen test and its application wrong. Ketanji's smarter than Alito and Thomas and Gorsuch and Kavanaugh and Roberts and Amy Coney Barrett. She's smarter than them. The majority got it wrong. Hawaii's law, she says, does not implicate the Second Amendment because there is no right to carry a gun onto private property without consent, as all agree, and the Constitution does not dictate the form of that required consent. And even if the Second Amendment were implicated here, Hawaii has proffered ample analogs, the matching game, demonstrating a history of tradition of states protecting the residents' property rights by requiring those wishing to carry guns on the private property to get express consent from the property owner. She's talking about the anti-poaching laws and the anti-black laws. For what it's worth, she writes, this is what it's worth. For what it's worth, I think Bruen was wrongly decided. Yeah, we know. That's why you're always in the dissent. You're an idiot. But if Bruen is going to be our precedent, the majority should at least endeavor to apply it faithfully. There's the insult. The majority is not even endeavoring to apply its own precedent faithfully. It's doing so unfaithfully. Unfaithfully. I respectfully dissent. Is she dissenting respectfully? Because the majority has failed to do so here. And its analysis and conclusion only further bind the hands of modern legislatures attempting to balance and protect their residents' interests. Well, you can't balance civil rights. There is no balance. The reason the civil rights exist is to protect the rights of the minority against state infringement. It's not balancing. That's the whole point of Heller and Bruen. There is no balancing. It's not like restrictions on driving. There's no constitutional right to drive a car. There you get balancing because it's not a constitutionally protected privilege. Keeping and bearing arms is. The balancing goes away. With this decision, the court has now manipulated Bruen into a free-for-all that lets the judiciary thwart the will of legislatures by privileging access to firearms above all else. Well, this case doesn't have anything to do with access to firearms. You can have the access to the firearm. That's not an issue here. It's a question of once you have access, where can you carry? What an idiot. Today's decision makes one thing clear. The Supreme Court's objective is protecting guns. Guns, the inanimate objects. Is that what this decision is about? Protecting guns? Guns are more protected now? Or is it the carry of guns by people, by we the people? Not consistently preserving any principle of law. Again, that contempt. And then she gets into the rest of her nonsense, which I'm not going to cover here. Let me catch up on any super chats and Rumble rants. Oh, we got a bunch of Rumble rants. And we are, of course, all here. Which we're going to wrap up over the next few minutes, and then we're going to transition over to today's members-only show, which is looking at the ending of TPS, putting the temporary back in temporary protected status. Another seminal decision from the Supreme Court yesterday, protecting our nation's sovereignty. But before I do that, let me catch up on the Rumble rant. Whoops, darn it. You know, whoever designed this StreamYard button layout should be taken out and shot. The button for share and the button for stop sharing are like right next to each other. Be Job Secure writes, thank you for covering this, sir. Very informative being in the Branca bunch. Yeah, it's my pleasure. I almost didn't because the decision came down yesterday. Everyone was covering it yesterday. Naturally enough, if I was in the office, I would have been covering it yesterday. But I was in flight, so I couldn't do it. But it's so important, I didn't want to let it pass without covering it. Even though I know our analytics for today will probably be lower than normal. Zakuza, $5. Aloha, can aloha these nuts? Indeed. King of Biltong, good morning, Andrew. Hope you sampled the biltong and received a second shipment. A second shipment? Let me know, please. I'll let you know about the second shipment. $10. Thank you, my friend. I appreciate that. I have to get a notice from our mailbox about it. I don't think I have yet, but I'll check today. And then we have a couple of super chats. Well, a few. Darren Miller became a member for 6 months. Welcome to the family, Darren. Oh, has been a member for 6 months, rather. Hey, Branca, is it possible to turn on the frequency of the ads? I get one every 3 minutes. Really? I don't have it on the high setting. I'll double check to make sure the setting hasn't been changed. We leave it on the default, which is the middle ground. Obviously, I don't control that except for that setting, but I'll take a look at it. Or my friend, I mean, you know, YouTube Premium's not that much. I mean, that's what I do to avoid the ads. I hate the ads too. Or Telios, member for 10 months. Thank you for that support, man. Says, hey, Branca, help me, please. My wife stole my mug because it's so huge. The huge Trump $250 currency mug. And will not give it back, so I ordered more. Well, that's awesome, man. In fact, I think I forgot to put the mug link in the chat. The mug. Let me do that. All our mugs. And we like this mug. We have different mugs. You can see a bunch of the mugs over my shoulder here. Mugs and travel mugs. We have the What Kind of American Are You mug. We have the BAM, Branca Show mug. That's supposed to be me there. But all the mugs can be found at this link. I'm going to pin in the chat. There you go. Whoops. I'm going to put it in Rumble too. And I'll put it in X as well. All right, yeah, order mugs. They've been very popular, very popular. Karen Brown, 7395 member for 2 months, says, off topic, isn't the VP the head of the Senate? As such, can he be a Senate majority leader? Easy vote to replace Thune. I mean, the Senate would have to vote for him. I don't know if you have to be, if he's eligible to be the Senate majority leader. He's referred to as the president of the Senate. I have to be honest, I'm not sure how much authority that gives him over anything, except for breaking ties. That one we're all familiar with. Okay, folks, so we are currently here. We just covered Wolford, the vampire rule decision out of the Supreme Court yesterday, and we are about to transition over to here, which is a members-only show. So you need to be a member to join us. It's only 16 cents a day. Well, it went up a little bit. I think it went up a couple bucks, but it's inexpensive to be a member. It's well under $10 a month to be a member. That doesn't affect the existing members, by the way. Your membership cost is frozen. It stays the same. It's just new members who join. It's very inexpensive. You get double the Branca Show content, and we're going to switch over to TPS. The defeat of TPS, temporary protected status, is once again temporary, despite unelected black robe, tyrannical, inferior federal district trial court judge pretending that they had the authority to block the will of the Article 2 executive to end TPS for hundreds of thousands of third worlders in our nation. That is what we're going to transition over to right now. In fact, I'm going to go ahead and start that stream going. Get the background music running. Temporary Means Temporary is going live on YouTube for members and on locals. The links for those are in the description. If you're on YouTube, you may be auto-redirected over there. That would be my hope. But in any case, we got a late super chat. A member for 8 months. As someone who has to live in Hawaii for the next couple of years, this was very good news. I can only imagine what a packed Dem court would do if given the chance, now that they're bitter from losing so much. Yeah, they're keeping a list of all the Clarence Thomas, all the Alito, all the Gorsuch decisions that they would like to reverse, for sure. They would reverse summarily. I guarantee you they have it all lined up. All right, folks, I'll see you all there in just a minute at Temporary Means Temporary. Until then, I remain attorney Andrew Branca for The Branca Show. Stay safe.